If you own a suppressor, a short-barreled rifle, or you've been sitting on a pending Form 4 application waiting for ATF approval, a ruling out of Texas this past week directly affects you, but almost certainly not in the sweeping, immediate way headlines are describing it. I want to walk you through exactly what you should actually be doing right now, this week, based on what this ruling really covers, not the exaggerated version claiming the NFA has been permanently struck down nationwide. Getting this wrong isn't a small mistake. An NFA violation carries up to 10 years in federal prison, a $10,000 fine, and forfeiture of the firearm, with a felony conviction triggering a lifetime firearms ban on top of that. So let's get the practical details exactly right, because this is exactly the kind of situation where excitement about a genuinely good development for gun owners can tip over into a genuinely costly mistake if you act on the headline instead of the actual court order. Before we get into it, if you want accurate, practical guidance on rulings like this instead of hype that could genuinely get you in legal trouble, subscribe and turn on notifications right now. This is exactly the kind of story where the gap between the headline and the actual court order matters enormously for real decisions you might be making about your own firearms collection. And getting that gap wrong carries consequences that a correction video days later can't undo. Let's get into exactly what you need to know. Here is the plain version of what happened. On August 5th, 2026, a federal judge in the Northern District of Texas ruled that the National Firearms Act's registration and approval requirements for suppressors, short-barreled rifles, short-barreled shotguns, and a category called any other weapons are unconstitutional, because Congress reduced the tax attached to those requirements down to $0 as part of a 2025 tax bill, and the judge found the registration machinery could no longer be justified once the tax it was supposed to support disappeared. That's a real, significant ruling. But several critical details determine whether it actually changes anything for you personally, right now, this week. The first segment is the single most important thing to understand: who this ruling actually covers. Judge Hendricks's injunction is party-specific, meaning it only protects the actual plaintiffs in these two consolidated lawsuits. Several advocacy organizations, including the Second Amendment Foundation and the Firearms Policy Coalition, along with their documented members, plus customers of three specific companies named in the litigation: B&T USA, Palmetto State Armory, and Silencer Co. If you are not a member of one of those specific organizations and you're not a customer of one of those three specific companies, this injunction does not currently protect you, full stop. This is genuinely the most commonly misunderstood part of this entire story, because most headlines simply say the NFA was ruled unconstitutional without ever mentioning that the actual legal protection only extends to a defined, limited group of people and companies. The second segment is the timing, because even for the people this ruling does cover, it wasn't immediately in effect the moment it was issued. Judge Hendricks stayed his own injunction for 7 days, specifically to give the federal government time to seek emergency relief from the Fifth Circuit Court of Appeals. That stay period runs out around August 12th or 13th. Unless the Fifth Circuit steps in and extends that stay further while it considers an appeal, the injunction becomes operative for the covered plaintiffs after that date, not before. If you're reading or watching this before that date has passed, the existing NFA process, fingerprinting, photographs, notifying your local chief law enforcement officer, waiting for ATF approval, still applies to everyone, including the plaintiffs, exactly as it did last week. The third segment is what to actually do if you're currently in the middle of an NFA application process, because this is the situation generating the most genuine confusion right now. If you have a pending Form 4 application for a suppressor or short-barreled rifle, this ruling does not mean you should stop the process, ignore ATF communications, or assume your application is now unnecessary, unless you can specifically confirm you fall under this injunction's protection, meaning you're a documented member of one of the named plaintiff organizations or a customer of one of the three named companies, and even then only once the stay has actually lapsed. Continuing to follow the existing legal process remains the only safe path. Think about the practical risk calculation here. If you stop your application process, or worse, attempt to acquire or build a regulated item outside the existing legal framework based on a mistaken belief that this ruling already protects you, and it turns out you don't actually qualify as a covered plaintiff, member, or customer, you've potentially exposed yourself to serious federal criminal liability based on a misunderstanding of a court order you likely never read in full. If you're unsure whether you qualify as a covered member or customer, the organizations involved in this litigation are the correct source to contact directly for clarification, not general online forums or secondhand summaries. And most of these organizations have been fielding exactly this kind of question since the ruling came down and can likely give you a direct, specific answer about your own status. The fourth segment is the marketing you're likely to encounter from retailers in the coming weeks, because some businesses have already started running promotional language, suggesting no more paperwork, no more registry, no more waiting. Read this kind of marketing extremely carefully. The responsible, accurate versions include a conditional phrase, something like once the injunction goes into effect, language that is doing enormous legal work that a quick glance easily misses. A retailer running this kind of marketing without that conditional language or implying the change already applies to every customer regardless of their specific legal status is giving you information that could lead directly to a federal firearms violation if you act on it. If a business is telling you that you can simply purchase and possess one of these items today without going through the existing process, and you are not specifically covered by this injunction, verify that claim independently before acting on it, because the business's marketing enthusiasm is not a legal defense if federal agents show up at your door. The fifth segment is what happens next procedurally, because this story is far from finished. The Department of Justice has a clear path to appeal Judge Hendricks's ruling to the Fifth Circuit Court of Appeals, and given the significance of this decision, an appeal is widely expected. If the Fifth Circuit disagrees with the enumerated powers reasoning Judge Hendricks relied on, this entire ruling could be reversed, which would mean the existing NFA process resumes applying to everyone, including the current plaintiffs, exactly as it did before this ruling. If the Fifth Circuit affirms the ruling instead, the practical protection could potentially expand, though the exact mechanics of how that would work for gun owners outside the original plaintiff group remain genuinely unclear and would likely depend on the specific language of whatever the appellate court decides. The sixth segment is the state law layer because federal NFA changes don't automatically translate into changes at the state level. Many states have their own laws specifically referencing the federal NFA when establishing their own requirements for suppressor or short-barreled rifle ownership. If federal NFA regulation genuinely changes for a broader population down the road, some of those state laws could become confusing, redundant, or in certain cases directly contradictory, since they were written assuming the federal registration framework would remain exactly as it always has been. South Dakota has already moved to adjust its own state law in anticipation of federal deregulation, and other states are reportedly considering similar moves. But this state-level layer adds yet another reason why assuming a clean, uniform, immediate national change is inaccurate, since your own state's specific law matters just as much as the federal picture for determining what's actually legal where you live. Even in a state that has already moved to align its own law with anticipated federal deregulation, that state-level change doesn't override the federal question of whether you're actually covered by this specific injunction, meaning you could theoretically be fully compliant with a permissive state law while still facing federal exposure if you're not one of the covered plaintiffs, members, or customers this ruling actually protects. The seventh segment is the bigger picture worth understanding if you want to actually follow where this goes. This ruling deliberately avoided deciding whether suppressors and short-barreled rifles are protected by the Second Amendment at all, a much broader constitutional question that remains completely open regardless of how the appeal of this specific ruling turns out. That means even in the best-case scenario for gun rights advocates, where this ruling survives Fifth Circuit review entirely intact, the underlying constitutional status of these items under the Second Amendment itself remains a separate, unresolved legal question, one that could resurface in future litigation regardless of what happens with this specific enumerated powers argument. Let's step back and name what actually matters most for you personally right now. If you're not a documented member of one of the named plaintiff organizations or a customer of one of the three named companies, nothing about your legal situation has changed yet and won't change from this specific ruling alone, even after the stay lapses. If you are potentially covered, confirm your status directly with the relevant organization or company, before making any decisions based on this ruling. And understand that even confirmed coverage remains subject to reversal if the Fifth Circuit disagrees with the district court's reasoning on appeal. It's worth acknowledging why this particular ruling generated so much excitement and, with it, so much room for exaggeration, because that context matters for understanding how to approach the next big gun rights headline you encounter too. For gun owners who have spent decades navigating NFA paperwork, waiting periods, and the general hassle of the registration process, a federal court calling the whole system unconstitutional feels like the kind of news worth celebrating loudly and immediately, and that emotional reaction is genuinely understandable. But the specific, careful, party-limited way this ruling was actually written reflects a judge being deliberately cautious, avoiding broader constitutional questions, limiting the injunction's scope, and building in a stay specifically to give the government a fair chance to appeal, all signs of a court trying to write an opinion that will actually hold up on review rather than one designed to make the biggest possible splash. That carefulness is exactly what got lost in translation once this story hit headlines and social media, and it's worth remembering that pattern the next time a similarly exciting gun rights ruling comes down, because the actual court order is almost always more careful and more limited than the version that goes viral. If you take one thing away from this breakdown, let it be this. A genuinely significant legal ruling deserves a genuinely accurate understanding of what it actually does, especially when the potential consequence of getting it wrong is a federal felony charge. Do not change your behavior around NFA items based on a headline alone. Confirm your actual coverage status, understand the stay timeline, and watch for the Fifth Circuit's response before assuming anything has permanently changed for you personally. If this helped you understand what to actually do instead of what a misleading headline implied, share it with someone who owns NFA items and might be confused right now. Subscribe so you catch the Fifth Circuit's ruling the moment it happens, and I will see you in the next one.